Hello everyone. Today we will discuss a topic under banking and insurance law. Today's topic is SARFAESI Act 2002. It is the part one of this particular topic. Here we will discuss about the act, what is the objective of the act and certain definitions under it and the process for securitization. The list of topics to be covered here is introduction. We will talk about the Act, then the objective of Act, certain definitions under Act, then section 13, which relates to securitization and the procedure under section 13. The financial sector has been one of the key handlers in India's efforts to achieve success in rapidly developing its economy. Since our existing legal framework relating to commercial transactions has not kept pace with the changing commercial practices and financial sector reforms, the SARFAESI Act 2002 has empowered the banks and financial institutions with vast power to enforce the securities charged to them. This ensures the slow pace of recovery of defaulting loans and escalating levels of non-performing assets, which is also called NPAs, of banks and financial institutions. It is an act to regulate securitization and reconstruction of financial assets and enforcement of security interest and to provide for a central database of security interests created on property rights and for matters connected therewith or incidental thereto. Here, SARFAESI Act mostly deals with a power given to banks and financial institutions for the recovery of their defaulting loans. When banks and financial institutions provide loans to people in the market and by certain reasons those people cannot complete their loans or they cannot repay the amount to the banks, then those banks and financial institutions under this act recovers the payment of those defaulting loans from those people. The main purpose of the SARFAESI Act is to enable and empower the secured creditors to take possession of their securities and to deal with them without the intervention of the court, and also alternatively to authorize any securitization or reconstruction company to acquire financial assets of any bank or financial institution. Here, under SARFAESI Act, all the secured creditors, that means which have the proper amount of to recover the particular loan, the banks and the financial institutions want these secure creditors to take possession of the securities. That means the on particular things upon which the loan has been taken, whether it is a business or any property. Then the banks and the financial institution want these secured creditors to deal with those securities and so that the loan amount could be recovered, but they do not want the intervention of the court here. So this particular act does not deal with the intervention of the court. It allows all the secured creditors to work there on their own. Then here is a concept given of securitization and reconstruction companies also, where these companies acquire the financial assets of bank and financial institutions and try to manage those assets or the businesses in the market to recover the loan amount for the bank and financial institutions. So here, the main objectives of this act is to enable and empower the secured creditors. They want to creditors to take the possession of the securities of the banks and financial institutions. The objective of this act to that is that there should be no intervention of the court. They want to authorize any securitization and reconstruction company to acquire financial assets of any bank or financial institution. Now let's discuss certain terms which are defined under the Act, and these are the certain important definitions. First is asset reconstruction. Asset reconstruction means acquisition by any asset reconstruction company of any right or interest of any bank or financial institution in any financial assistance for the purpose of realization of such financial assistance. Here, asset reconstruction is that when any reconstruction company acquire any right or interest of any bank or financial institution where the main purpose is that the to realize the particular financial assistance of that particular bank and institution, that is the asset reconstruction. Here bank means a banking company, a corresponding new bank, a state bank of India or a subsidiary bank, a multi-state cooperative bank, such other bank which the central government may by notification specify for the purpose of this act. One of the important section under SARFAESI Act is Section 13. It deals with the enforcement of security interest by creditors. Here, this section provides that where any borrower who is under a liability to a secured creditor under a security agreement makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt is classified by the secured creditor as a non-performing asset. First of all, there should be a borrower who is under a liability to a secured creditor, and there should be a security agreement, and that particular borrower has made a default in repayment of the secured debt or the loan which he has or she has taken, or any installment thereof. There is a default in the repayment of any installment, and his account in respect of such loan is classified by the secured creditor as a non-performing asset. That means his loan has been declared as the non-performing asset. Then the secured creditor may require the borrower by notice in writing to discharge in his full liabilities to the secured creditor within 60 days from the date of notice, failing which the secured creditor shall be entitled to exercise all or any of the rights. Here, when the borrower is in default of the repayment of the loan amount, then the secured creditor may give the borrower a notice in writing to discharge his full liabilities. That means he want him to pay all the loan amount to the secured creditor within 60 days. 60 days time period has been given to the borrower to pay the loan amount, default loan amount, and from the date of notice, on the date on which the notice has been issued, the secured creditor shall be entitled to exercise all or any of the rights of the borrower. So within 60 days, if the borrower repays the loan, then it is fine. If it does not, then the secured creditor shall be entitled to exercise all the rights. The requirement of classification of secured debt as non-performing asset shall not apply to a borrower who has raised funds through issue of debt securities. Here, they are saying that the requirement of classification of secured debt as non-performing asset shall not apply to borrower. Yani, that means the borrower, the classification as the non-performing asset shall not apply to borrower, and he cannot raise any funds through the issue of the debt security. In the event of default, the debenture trustee shall be entitled to enforce security interest in the same manner as provided under this section, which with such modification as may be necessary and in accordance with the terms and conditions of securities documents executed in the favor of debenture trustee. In the event of default, the debenture trustee, they shall be entitled to enforce the security interest, and they can make such modifications which are necessary in accordance to the terms and condition of the security document. The notice shall give details of the amount payable by the borrower and the secured assets intended to be enforced by the secured creditor in the event of non-payment of secured debt by the borrower. The notice, there are certain um, elements of the notice which are required to be there on the notice. So whenever the secured creditor provides a notice to the borrower, these particular all the content should be there in the notice. First of all the amounts related to the all the detail of the amount which is payable by the borrower, they should be there. Then what are the secured assets which are enforced by the secured creditor, details regarding that should be there. On after In the event of non-payment of secured debt, if the borrower does not pay the amount, then all the secured assets which would be enforced by the secured creditor, or details of those secured assets should be there. If on the receipt of notice the borrower makes any representation or raises any objection, the secured creditor shall consider such representation or objection. If the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of the receipt of such representation or objection the reason for non-acceptance of the representation or objection of the borrower. In case the borrower fails to discharge his liability in full within the period specified, the secured creditor may take recourse to one or more of the following measures to recover his secured debt. He could take the position of the secured assets, or he could take over the management of the business. So this is the particular procedure under section 13, which is given under SARFAESI Act 2002, and this is the processor by which a secured creditor could enforce the security interest in the NPA.